morning. My name is Adam Romney on behalf of the subrogation plaintiffs who brought this appeal. We're going to reserve 4 minutes of time for rebuttal, please. Obviously, you've had opportunity to read the briefs. I don't want to read the briefs back at you. I think the important thing to keep in mind is that this is not a particularly difficult or novel set of facts or a case in the context of a personal jurisdiction matter. One of the things that I think is particularly clear when you look at the just volume of cases cited is that this exact or similar situations have been discussed by both the Supreme Court, district courts, and the circuit courts multiple times. You know, it's the context of foreign vehicle manufacturers who are selling their vehicles into the United States, and when those vehicles ultimately fail or cause injuries, there is ultimately a suit brought inside the district courts. The reason that it's happened over and over again is obvious. It's a mobile product. By its very nature, it's a product that travels around. It tends to move from one state to another. And so this has been tested multiple times. We cited in our briefs.
Is there another case in which you have this asserted difference between the distributor corporation and the manufacturing corporation? I don't know of one.
Another industry, when you say that kind of case?
You're saying there are all these similar cases.
Well, sure. I mean, so for example, we cited LW versus Audi AG, which is a case from this year that has been winding its way through post-Ford in the California appellate courts. And that's a case in which it had the exact scenario that you're describing. I believe that it said that the assertion of jurisdiction was appropriate because the reason for the domestic distributors to exist was to facilitate that direct, continuous, and purposeful contact by the foreign manufacturer.
So suppose that the domestic subsidiaries were not subsidiaries, but were just entirely independent companies, but everything else in this case were the same. How would that change the analysis in your view? So
there's two different, obviously, we're talking about an entirely different business model, so I'm going to give the two answers to that. The first is if it was an entirely different, it's not a subsidiary, they sell many products, including cars. That is closer to I think of them as like the board game and toy cases, like the KB cases that the defendants attempted to cite. In those cases, there is a product and they are selling it to a Walmart, for example. And the thing is that that's closer to a true stream of commerce. It looks more like Asahi Metals because it is not a dedicated sales channel. The customer is ultimately that retail channel that sells everything. So in that case, it would be closer. And the court would have to say, is this part of a demonstrated and continuous contact? But this case is not close in that sense because it is the sole reason for these distributors to exist is to sell this product into this channel, which is exactly LG versus Audi.
So I mean, to that extent, then, I mean, are you asking us to sort of impute the activity of the subsidiaries to the parent? Because, I think there are a lot of cases that say, absent some showing of, alter ego, which I don't think you've attempted, that we're supposed to respect the corporate form and essentially treat the subsidiary as if it is a separate entity.
So you're correct. This is not an alter ego theory. What we are describing are the actual actions by the parent companies themselves. And you can really see that that's true because our theory relies in large part upon the fact of a differential design, that it was the Korean companies who were making the decision to sell vehicles and produce and manufacture them with a different design for the American market.
And deliberately chose to send it through the port in California.
Yes.
It doesn't matter exactly where. There's some dispute, I gather, about where the ownership changed. Or do we have any evidence that the distributors actually ever had title to these cars?
Well, I think that is actually kind of a sideline. First of all, I think that is one of, in terms of the evidence itself, that's the LNS case that we cite, in which any dispute about the facts themselves are supposed to be resolved in the plaintiff's favor. And we did have a discussion of a number of entries. I think there were 8 or 9 in the original briefing before the district court that showed that the title was taken by the distributor themselves. And I think that the court
And where and
improperly.
when? Before it got on the boat, after it got on the boat?
We're saying that.
While it was on the boat?
We were saying that it was shipped by, those 8 entries, they said it was shipped by the Korean company. So it was shipped to them and they did not take title till after the boat. Now, the defendants in this case, what they said is that those were clerical errors and they submitted a declaration to that effect. But LNS Enterprises is clear that means that there is a dispute on the facts. And we cited a case that was Data Discovery versus System Tech Associates that says that it is not possible for the district court to weigh affidavits and determine credibility. So in the event that there is some dispute about that,
Recording stopped.
in the event there is some dispute about that issue, that is supposed to be resolved in our favor, which is
But
different.
I take it your principal legal theory is that it doesn't really matter where title passes?
That's correct. I think that's a sideline issue. This is part of what we describe as that it's the contacts themselves and it's the business model that's set in place by the Korean companies. They are the ones who made these decisions to create a specific model of these cars that was designed only for the American market. The language, I think, of Ford in particular really goes that this is a continuous, it is a designed path in which those vehicles are designed for this market. That is a design strategy set by the Korean companies. It is a sales strategy set by the Korean companies. As the American companies themselves cannot ever be the ones who are saying.
So you allege that this design defect was designed particularly for the American market?
Yes, that is a primary allegation in the complaint. And this is actually one of the reasons that this is important that the Korean companies need to be in the case. One of the arguments that the defendants have made is that it shouldn't matter as long as there is a solvent company. But because the design decisions themselves are made at the Korean manufacturer level, having the Korean defendants in is important for actually prosecuting the case for liability
But in
and
terms
discovery.
of evidence of that allegation, it's primarily, I guess it's more allegations. I don't know if we have any declarations or anything that show that these defects were not in the cars that were shipped to Canada and Europe.
I don't believe
But
that.
is there any documentation of any of this?
Oh, that is absolutely true. I mean, for one thing, first of all, this was not disputed by the defendants. That was not the basis of their dispute.
So is that, and from there, from that fact, you're concluding that there was a decision made to make a different design for the United States?
Yes.
And
so,
that's it. I mean, there's nothing
well,
else.
that is the most obvious and clearest one. The reason is that this is the part in question, which is an engine immobilizer, had to be included as a standard feature in, for example, Canada, but it was introduced as an optional trim package so they could upsell customers in the United States. Now, that decision that in every other country in the world, it is mandatory, it is always in, but here in this market, that part is not included as a standard package. It means that design, without that part, could only have been purposefully directed at the United States market.
Is there any discovery that you could and would do that would be helpful in resolving this?
There would be discovery, but it would require us to have the Korean entities in the case. And that's actually what we've seen play out with the discovery in this case.
But there's jurisdictional discovery.
Well, that's I think that could be jurisdictional discovery, but I think that, Your Honor, I think we saw at the district court level, the district court, seemed to suggest that enough evidence already existed to.
Well, I understand that, but if we thought that this was at all close, would it make more sense to have more discovery, and what would it be?
Well, yeah, I think that the discovery we had initially asked for would try to drill down on this issue, and but
Which
again,
was what? What was the discovery?
Again, it would be what was the extent, who made the decisions, what was the differential design, what was the trim patterns, so that kind of like decision making at the Korean company level.
And do you think that would be appropriate jurisdictional discovery?
Well, I don't think that we need to get there because, again, this is not that there is a differential design. It was not really disputed. I don't think that is in dispute. But to the extent that it would be helpful, it would be appropriate to grant us jurisdictional discovery rather than simply dismissing the case outright.
I have one other question. And this may be not worth worrying about in this case, but Asahi and the follow-on case in the Supreme Court, who's Nicastro or something like that, neither of them had a majority opinion on the stream of commerce theory, but nonetheless, everybody's always taken them as having decided that the stream of commerce wasn't good enough. Do you have any idea how we have gotten here?
How we got to...
I mean, are we to take it? I mean, you're saying this isn't really a stream of commerce case, but I don't know that there is a stream of commerce case. I mean, the Ninth Circuit seems to think there is one, maybe.
No, I mean, so remember, Asahi actually said that, a stream of commerce by
But
itself
that was a
wasn't enough.
plurality opinion.
I know, but what I'm going to say was then shined on by the majority of justices, which is that if there was something more, which is the quote from Asahi was, if the manufacturer created, controlled, or employed the distribution system.
Yes, that's
that brought
right.
it
You did
in.
say that.
And that is exactly the allocation that we've
Right.
made here with
Exactly.
this action.
So, I mean, in your view, is it the case that basically any time you have a foreign manufacturing company that has a U.S. subsidiary whose function is to distribute the products in the U.S., and I would assume in that situation, like inevitably, the products get shipped by somebody, either by the foreign parent or the U.S. subsidiary. Somebody ships them here. The parent obviously knows that they're going to be shipped here and intends that. So is there jurisdiction over the parent in basically all of those situations?
Yeah, I think that we would say as long as you are shipping it to that market. I can imagine, for example, like transshipment situations where, let's just say it was shipped here, but the port was only used intermittently because it was actually going to South America. I mean, that would be one where they did not purposely direct the shipment to this market, for example. They didn't avail themselves, even though they put it on the boat and knew it would touch here. I think that actually one case that was decided by this circuit, it was actually your opinion, Justice Wardlaw's Shopify, Briskin v. Shopify in May, and I think that is actually useful because that is a case in which it is more abstracted. It's about computer cookies that were sort of put onto people regardless of where they were. And one of the arguments that they had made was to say that their sales practices, because they were digital, is they were jurisdictionally nowhere except in their principal place of business by virtue of that business model. And this court rejected that argument. And so if that argument were even
Rejected
like a
it
digital...
because the Supreme Court rejected that argument in Ford.
Exactly. And Ford is the argument that we think applies here. Ford adopted the Daimler-Chrysler, the Daimler decision as truly binding, on all courts. And that's part of the reason that we brought to you all the new Samsung case, from the Fifth Circuit in May, in which it recognized that decision was ultimately affecting a sea change in this area of the law. It is a thing that is almost indisputable. I don't know how it is that they could possibly get out of it because it is on all fours. It describes, what happens when you have a vehicle directed to California with a California plaintiff who is injured in California. That is this
So
case.
the district court didn't have the benefit of Ford and Shopify, I don't think.
No, Shopify was decided in May, but it is the law here.
But Ford was prior.
But
Ford
Ford
was-
was,
yeah.
was previous. I don't know if the district court had the benefit of Ford. And
Well,
just-
it did have the benefit of Ford. Ford was decided in 2021.
But Ford is really about arising out of or related to. It doesn't change the meaning of purposeful availment, or do you think it somehow does?
No, I don't think it changes the meaning of purposeful availment. And I think that part of the reason, I know I tried to reserve more time, so I will answer your question, but I don't think it changed the meaning of purposeful availment. I think part of the reason that Ford said we acknowledged that this other line, this other reasoning in Daimler-Chrysler is controlling is because it was a recognition that was how the courts across the country were actually applying it. That was a recognition of reality. So it didn't change anything, but it essentially instructed this is the law, and that's what you saw the Fifth Circuit say is we now recognize that this is the law. So I'm going to reserve the rest of my time.
All right. Thank you, counsel.
Yeah.
I'll give you a couple minutes for rebuttal because we took you over, but
Okay.
you're out of time.
Thank you.
Okay, thank you.
Good morning, Your Honors, and may it please the Court. Andriana Kostanek on behalf of Hyundai Motor Company and Kia Corporations. The concession that was just made by counsel that his theory of jurisdiction would mean that every manufacturer, every foreign manufacturer would be subject to U.S. jurisdiction, not just U.S. jurisdiction, but California-specific jurisdiction, if they use a third party to distribute a good to the United States market. That concession cannot be overstated.
Well, I don't know
This
that
is-
he said third party, and that's really the question. He said, or a subsidiary affiliated party, a totally dedicated party.
Yes, and that matters, Your Honor, to go to Judge Miller's questions. It matters that this is an independent subsidiary. So the relationship here is there is corporate separateness between the subsidiary and the foreign parent companies. The unambiguous record.
Suppose this independent distributor had decided that it wasn't going to sell any cars in California. We're taking all the cars that got to the California part. We decided we're not distributing any cars to California anymore. Are we supposed to believe that the company in Korea would say fine?
I'm sorry, if the subsidiary said,
Yes.
I'm not going to sell cars in California, I don't know what you would believe in that situation, but the unambiguous record evidence here that is not disputed is that there is a process of manufacturing and designing in Korea, that the Korean corporations only do business in Korea. They sell those vehicles in Korea, and title passes in Korea. Everything after that point is the exclusive responsibility of the U.S. subsidiaries. And
Right, but
as
I guess this is sort of picking up on Judge Berzon's point. It's not like they hold an auction at the gate of the factory and then somebody buys them and who knows what happens after that. I mean, like, they have created an entity to sell them in the United States. They are, we can sort of debate where the title passes, but like they are, putting them on the boats to ship them to the United States. So it does seem like there is action, even if we just look at what they're doing, there is action directed at the United States, isn't there?
Along those lines, how do you distinguish our decision in Yamashita, where the defendants qualified as purposeful availment of Hawaii's jurisdiction by shipping products through the port of Honolulu?
So if I can take the first question first, because I think that this matters a lot. So where there is a U.S. subsidiary and there is a corporate separateness in between them, we are told by the Supreme Court that you need to respect that corporate separateness. So, in fact, even last term in a case called Dewberry, a trademark case before the Supreme Court, the court said yet again, it is long settled as a matter of American corporate law that separately incorporated organizations are separate legal units with distinct legal rights and obligations.
Right, but
You
the
treat them.
distributor did not make the decision to ship the cars through the port of California. And that's why my follow-up, because I know that was your answer from reading your briefs, my follow-up is, then how do you distinguish Yamashita? Because it was the Korean company that made the deliberate decision to ship to California.
There is zero evidence in this record
Well, that's
that there
the
was a
allegation.
deliberate decision by the parent companies to ship into the port of California. The evidence that does exist comes from the declarations that were provided by HMC and KC, the Shin and the Biak declarations, and they say that the subsidiaries control everything from the point that it gets onto that ship. They have
I know,
legal
but it was
responsibility
put on the ship,
for-
and the ship was going to California.
Correct. I mean, if the point is that they knew that it was going to California, we know from the plurality opinion in Jay McIntyre that that foreseeability, the idea that they could foresee that it was
Right,
going
but
to
again, as I
California
said
is
before,
not the
in
same.
both Asahi and Jay McIntyre, those are plurality opinions, and the majority of the justices seem to be saying otherwise. I'm sort of
Yeah,
mystified by
The-
why everybody cites them as if they're controlling.
Well, because Justice Breyer and Justice Alito had a concurring opinion in Jay McIntyre, and while it was limited to the facts, there is a very important statement in the Breyer opinion that says that he does not agree with the decision of the Supreme Court of New Jersey in that case, which had adopted a rule that sounds a lot like the questions that you're asking here. So he specifically rejected a rule that, quote, would permit every state to assert jurisdiction in a products liability suit against a domestic manufacturer who sells its products made anywhere in the United States to a national distributor. So that's what we have here. You know, this is the analogies that were drawn by Justice Kennedy in his plurality opinion that, you know, simply because you know that your goods are going to end up in a particular state is not enough to create purposeful availment.
On this record, who shipped the product? Who chose where the product was going to be shipped to?
The record is silent on that question, Your Honor. The record does not reflect definitively who made that choice. However, it's a fair inference that from the facts that are in the record, including the declarations, that the decisions over where the goods were received and where they were distributed to in the United States was actually a decision by the subsidiaries. They handle all contracts. They handle all issuing issues with respect to the distributors in the United States and the dealerships.
Really, it's just not a believable story. I mean, the notion that Hyundai Manufacturing Corporation in Korea is indifferent as to whether any cars are sold in California just can't be the case.
Well, I guess I disagree, Your Honor. I think it is very believable that they have set up their business in a way where they manufacture and they sell in Korea. They have U.S. subsidiaries, which, as Judge Miller had noted, are not alleged to be alter egos or agents in this situation. That's very important. That was waived below. It's waived on appeal. They do not pursue the idea that there's like a lack of corporate formality here. So they are putting these vehicles into a stream of commerce via what's considered under very established corporate law to be independent third parties. And they do that in all kinds of different countries, including to the United States. They don't differentiate between the states, and this is reflected in the arguments with respect to the design of these vehicles, too. None of that is California specific. I'm sorry, go ahead.
To change we're about to argue the consumer cases. In those cases, the Korean entities are the defendants, and there was no personal jurisdiction objection.
Well, that's not quite correct, Your Honor. There was a stipulation reached. There was consent in those cases by the foreign parents. It's clear on the record that that same stipulation was offered to the plaintiffs in the subrogation track, and they rejected it. And so that is an express consent by the foreign parents to be subject to jurisdiction in those other tracks due to an agreement that was reached with respect to how discovery would be conducted.
You said a moment ago that the record doesn't reveal who made the decision about where the ship's going to go when they put it on the ship. Why should they not be entitled to jurisdictional discovery to investigate that question?
Well, first of all, two reasons. The first is that it is very clear that the jurisdictional discovery below was just a fishing expedition. They had 30-some requests that ranged everything from the economic analyses of immobilizers to the decision to distribute to other locations, right?
Okay, well,
and
that
the
may
district
be,
court,
but limited to this
putting that
question.
aside, because but it is important to what the procedural point that I'm going to make, which is that the district court said to the plaintiffs, I'm going to deny this motion for jurisdictional discovery without prejudice. At record page 1616 of the ER in this case, the district court said, you can come back. Let's brief jurisdictional discovery here, and you can come back with pinpoint discovery requests if there are specific facts that you think are, a hole in your theory. You can come back to me. And the plaintiffs chose not to. So I think at this point it's waived. They never came back and asked for the court to, reconsider or to have a more limited discovery request to the court for something like what you're saying here. And actually, I understood the argument here of my friend on the other side to say, we don't need jurisdictional discovery. That's not important to us. If I can take one moment and talk about the Shopify decision, because, I understand that this came out after the district court's opinion in this case. I strongly disagree that this opinion is beneficial to the plaintiffs. So first of all, the case was not about corporate structure. So Shopify was a unitary company. It did all of the activities, including in California by itself. So it didn't involve a third-party distributor or a third-party subsidiary. And in fact, the California contacts of that corporation were the polar opposite of HMC and KC. So in this case, we have no contacts with California. All we have is this unadorned stream of commerce theory where they're putting these vehicles into the stream of commerce through a port in California. And the contacts in Shopify were, the idea that they didn't need to be California specific is because they had contacts everywhere. So one quote from that opinion is, Shopify knows about its California consumer base. It conducts its regular business in California. It contacts California residents. It interacts with them as an intermediary for its merchants. It installs software onto their devices in California, and it continues to track its activities. In other words, there was substantial business and purposeful direction in that case. In this case, of course, is a purposeful availment case, not a purposeful direction case. But all of those contacts are wholly absent on this record, nor is the injury felt here in California. And if I can spend one moment talking about the Ford case, because as Judge Miller noted, it really is about the relatedness prong and not about purposeful availment. Purposeful availment in Ford was conceded. The court called it a veritable truckload of contacts across the United States that made it unnecessary to deal with purposeful availment. But on the relatedness prong, what Ford says is that there has to be a relationship between the state, and in Ford, that was the injury having occurred here. Bristol-Myers, which postdates Ford, says where the link to the state is simply that goods are being distributed via a distributor in the state, but the injury and the sale in question to the particular plaintiff didn't occur in the state, there's no specific jurisdiction. That is this case. The contacts in this case are nationwide. There is no identification, zero identification in the complaint of any California injury, any vehicle that was stolen in California, any insurer that insured a particular insured in California. All of that is absent from the complaint, and to the contrary, the complaint spans all 50 states. It alleges injuries across the different states, including ones that are not limited to California. So this is a Bristol-Myers situation.
I thought it had a whole bunch of state-specific allegations.
Yes, there are state-specific allegations insofar as they say, under New Jersey law, we bring New Jersey negligence claims, et cetera. And that's precisely my point, is that they do not identify any particular vehicles or insureds that were located in California. And to the contrary, there is all kinds of injury vehicles, insureds that are outside of California that don't satisfy that relatedness prong of specific jurisdiction. And that matters because as we know from the cases that do exist and the clear statements that do exist in the stream of commerce context, specific jurisdiction is very different than general jurisdiction. You need not only those contacts and purposeful availment with the jurisdiction, but also the link to the litigation.
If I recall, this is not a case from state court, it's a case from federal court. The rule that requires that there be California connections is a statutory rule. Is that right? It's not and there is nationwide jurisdiction under certain circumstances.
Yes,
so there's no constitutional problem here.
Well, I don't think that that's quite right, Your Honor. So they invoke 4K1, which borrows the state, the California long-arm statute.
It's statutory.
And then the California long-arm statute, in turn, is coextensive with the federal Constitution. So it says we are as broad as the Due Process Clause allows us to be.
Yes, but as far as federal court goes, the requirement is not constitutional. That has to be the case because there's national jurisdiction in a lot of statutes.
I suppose, except for that we know from cases like Ford that the limitations on the state being able to exercise its jurisdiction is provided by the Due Process Clause. There has to be minimum contacts that satisfy.
Yes, but minimum contacts with what? With California or with the nation as a whole?
Why do they need to be specific to California?
That's because of the statute. It's not because of...
Jay McIntyre says it's a forum by forum, sovereign by sovereign analysis because each sovereign has to have the ability, and here it's, we're borrowing the California long-arm statute due to ERE.
Was McIntyre's case from state court?
McIntyre, I don't know
Probably.
if it arose from state court.
There's discussions about sovereigns and so on is from the state court cases.
I think it did arise from state court, Your Honor. But this isn't a case where nationwide. I mean, they specifically invoke 4K1, which is a state long-arm statute,
and
so
because the statute says so, but it's not constitutional. That's all I'm trying to point out.
I don't know that I agree with that because the California courts could not interpret, and the federal court interpreting California law could not interpret the long-arm statute to be broader than what the Constitution allows under the 14th Amendment, I think. I see I'm out of time, so if there are no further questions from the panel, we would ask that this court affirm the district court.
Thank you, counsel. I said I would give you 2 minutes to respond.
I'll try to make it quick. So first of all, I want to address this, California versus 50 state thing right off the bat. This is a real red herring. Remember, this is a multi-district court litigation. Ultimately, the reason there are 50 state allegations is the defendants requested that there be a single master complaint filed at one point that included all of
Why
the
are we
allegations.
looking at California connections in particular?
What was that, sorry?
Why are we looking at California connections in particular?
Because that's
Or
the
are we?
site. Because that is where the MDL court is located, and that's
Right.
when they actually brought the motion itself, they cited the California court as being the one that applied.
But if it's an MDL and it was the courts that moved it over there, you wouldn't think it would,
It's funny. We literally looked into this issue yesterday, and what we have landed on is actually part of the answer is because the purposeful availment of the foreign manufacturer has a differential design that goes to the United States, and those vehicles end up in all of the different states. That whether you do it by 50 state, or you do it just by California, the answer ends up being the same.
but I think your problem is less if it's national, because these cars were obviously going somewhere in the United States, whether they were going to California. It's pretty obvious they were
they're
going to
routed
California too, but it's more obvious that they were going somewhere in the United States.
Yes, and it's particularly obvious with these vehicles they were going to California. As you put it, it is simply not a believable story that the foreign manufacturers had no idea, and that's the exact same argument that was rejected in Audi.
And
which is
didn't
that-
care. I mean, the notion that they didn't care.
Yeah.
It would have been fine if we said we're not going to sell any cars in California.
Yeah, that argument was rejected. The quote from Audi is that Audi, through its dedicated distributor, VWGOA, intentionally placed its vehicles into the regular flow of commerce to the United States, including to California. Since I've got 10 seconds left, the last thing I want to say, and I will answer another question, is they have conceded us. They did not mention at all the issue that disputes between the factual record that we had our affidavit from our person who looked at the customs records and the customs records themselves. To the extent that those conflict with their affidavits and declarations, that's supposed to be resolved in our favor. And the district court did not do that. That was conceded by them. They didn't address it at all. That by itself is reversible error that should lead to a vacation of the order. Do you have another question?
No, I don't. Thank you.
Okay, thank you very much. I appreciate your tolerance with me going slightly over time.
Yes, no, thank you. Thank both counsel. The first Kia Hyundai case will be submitted, and we're going to take a 5-minute recess before we return for the second one, so counsel can get all settled.
All rise. Court stands in recess.